As a brief introduction, my name is Ify. I am in my third year at Yale Law School. I use she, her, hers pronouns. And I've been a member of the Transitions MLP for a year, exactly a year, I would say. And I joined the MLP because I'm interested in challenging incarceration, and I've done work related to this while in law school, including legislative advocacy against solitary confinement, interning at a public defenders organization, some felon disenfranchisement work, some prisons condition work. And I also have a background in public health. My pre-YLS world involved getting my MPH and doing work in public health. So I kind of joke that I didn't want my master's to be in vain and look for ways to do public health things in law school. But it has been really enjoyable being a member of the clinic. And I'll pass it over to whoever wants to go next, introduce themselves.
I can go. Hi, everybody. I'm Elaine. I use she, her pronouns. I am also a third-year student at Yale Law School. I'm originally from Massachusetts, and my work in law school has mainly been focused on combating and ending incarceration and working with folks who are currently incarcerated and formerly incarcerated. I've been working with the MLP for, I guess, about 2 years now. And I'm really excited to be here. I was working in immigration legal services before law school, and one of the partnerships that we had at my organization was with a community health center, and we had a medical legal partnership there. So I was really excited when I came to law school and there was an opportunity to work in that same setting. I think that it's a great way to really meet people where they're at and not create additional administrative burdens to try and solve problems. And I'm very grateful for everything we've learned, and I'm excited to share some of it with you all today. And Atticus, I'll pass it on to you.
Hi everyone, my name is Atticus Ballesteros. I use he, him pronouns. I'm originally from Wisconsin. I'm in my third and final year at Yale Law School as well. Prior to law school, I spent a couple of years working with incarcerated people in ICE detention, DHS detention. And that got me interested in issues of incarceration and also policing, racial justice, and racial profiling. And throughout law school, I spent most of my time working with folks who are incarcerated, but I have not spent a lot of time with people after they leave incarceration. And so that was why I joined this Transitions MLP. I am very interested in ending incarceration and reducing the scope of it as much as possible. But I understand now from my time in MLP that getting someone out of incarceration is really just a first step to ensuring that that person can live a healthy and thriving life. I'm also really grateful that you're all here today to hear from us. And I'll just emphasize what Lisa said earlier, which is that this is very much meant to be a sort of mutual learning session. And so we do hope to get people's feedback, especially towards the end of the session.
Fantastic. I'll let you guys get started. I'm just going to say too, one of our lessons that we've learned here at the Transitions over there is we don't aim for perfection. We aim to kind of give it a start and keep modifying. So this is not a perfect document, and it's not a done document. And I just want to say that out loud for anyone who joined late. We're really trying to modify it, build it, grow as we hear from you all and other people who are using it. So thanks for listening with an open mind, and we're open to your feedback in the chat that we'll address at the end. Turning it back over to you guys.
Great, thanks so much, Lisa. So again, just gonna triple down on what Atticus and Lisa said. Please ask questions in the chat. We would really love this to be as participatory as possible. So I'll just go over our agenda for today, and then I'll pass it over to Atticus to kick us off. So we're gonna just be introducing what we do as the Transitions Medical Legal Partnership. We'll go over briefly just what it is that we're presenting today. We created this guide that is very much a work in progress. We'll explain a little bit about criminalized patients and what that means. We're going to talk about some general principles that we recommend when working with criminalized patients. We'll talk about communicating with patients' families, with criminalized patients' families, and some insights on interactions with law enforcement in a healthcare setting. Then we'll just talk a little bit about warrants, probation and parole, which are all words that as providers you might hear in relation to your patients, just so that everybody has a better sense of what those words mean and what the implications might be for their patients. We're going to talk a little bit about shackling policies within healthcare settings, and then just point folks towards a couple additional resources. And then we're going to ask for your feedback on what we've talked about, whether there's things that are missing. So as we go along, please feel free to either note down for yourself for in the chat if you're not able to join us for the last half hour of our presentation, or really any other way of memorializing your thoughts about what more we might be able to do, because we're really hoping to expand and improve upon our research so far. And with that, I will pass it over to Atticus.
Okay, cool. So as you noted, the title of this presentation is Advocating for Criminalized Patients. So we'll just do a quick overview of who exactly we are speaking about when we're speaking about criminalized patients. We start with the premise that health is determined, that much of a person's health is determined by social and environmental factors. So that includes income, access to healthcare and healthy food, housing, education, job stability, personal safety, and more. We also start with the premise that any interaction with the criminal system can and often does cause negative mental and physical health effects. That includes an arrest, that includes surveillance or harassment by police, that includes incarceration, whether temporary or in the long term, and that includes having a conviction on a person's record or any charges on a person's record. And when we're speaking about those things, we're not only speaking about an individual's sort of interactions with law enforcement, but also any interactions that people in your network are having with law enforcement. So if it's your family member, your neighbors, your friends, your coworkers, any interactions that they're having with law enforcement may also be having a negative mental and physical health effect on you. And these interactions with law enforcement don't only have sort of direct health effects, they also cause disruptions to people's socioeconomic stability. And we see that in our clinic manifesting as legal problems. So, you know, we meet with formerly incarcerated patients who have an array of legal issues that are spurred on by or exacerbated by their time in incarceration or their interactions with the system. So that includes, again, you know, struggles finding a job due to certain convictions, or getting an education, or access to public benefits that are necessary to survive, and things like that. So putting all that together, when we're talking about criminalized patients, we're talking about anyone who is disproportionately likely to have past, present, and or future interactions with the criminal system, and therefore have a greater likelihood of adverse health outcomes. And so as the slide says, we're talking about people who are, in particular, who are poor, Black, brown, disabled, trans, non-binary, Muslim, undocumented. And of course, there are other groups that are disproportionately impacted as well. And people whose identities sort of crisscross multiple of these identity characteristics are just that much more likely to be impacted. And we're going to touch on this a little bit more later on, but we've also found that healthcare providers, studies have shown that healthcare providers do harbor certain assumptions and implicit biases toward this population, as many people in society do. And that may impact how these patients are treated in the healthcare system. And it also impacts how they approach the healthcare system. And so we'll touch on that in more detail later on. So with that sort of set in our background, the Transitions Medical Legal Partnership, as stated before, we work with people who are transitioning out of prison in Connecticut, coming back into the community. We collaborate with Dr. Puglisi as well as other medical professionals inside Yale New Haven Health. And we as law students will do intakes at the health center regarding a patient's legal needs, with the goal of having like a one-stop shop where this person can get both their medical, health, and legal needs addressed. On the slide, you'll see a list of some of the common things that we see with our patients. Those include, in particular, like government benefits, like food stamps or disability benefits. Getting a government-issued ID can be particularly complicated, and it's like a first step that you need before you can do anything else after incarceration. And it is really hard for a formerly incarcerated person to get an ID in Connecticut. A lot of people have housing challenges. They may not be eligible for housing assistance or public housing due to their criminal background. They may be facing some kind of direct or indirect discrimination by landlords. Also, a lot of people just have bad living conditions like mold or flooding that impacts their health. A lot of people have workplace difficulties, and it's also very common for us to encounter family law matters like custody of children. So we sort of divide our work into two categories at the clinic. On the legal side, we do direct services. So we intake our patients, our clients, we talk to them about their needs, and then we interact directly with service providers, lawyers, and others to try and get folks the kind of legal service that they need. Sometimes we write letters to seek changes from landlords or employers. We also do a lot of sort of broader advocacy. So that may include, you know, testifying in favor of legislation in Connecticut, shifting policies like ID access, people's ability to get their IDs while they're incarcerated, for example. And then the sort of subject of today's presentation, which is over the last year, we've created what's called the Provider's Guide for Advocating for Criminalized Patients. And that's a guide that we're going to distribute hopefully in the near future to all of you and beyond. And it's going to touch on all of the things in this presentation. And it's a working document. We're planning to update it pretty regularly with feedback from medical providers. And so, as we've already stated, again, we're going to sort of go over the high level points of the guide today in this presentation, but we're really looking to hear from providers, you know, what can we frame differently? What can we add? What are we not talking about? Or even like, what are your own experiences working with criminalized patients that could help us shape this guide and help other medical providers improve their practices down the line?
Great. And like Atticus said, this does not include everything that we talk about in the guide, and it definitely does not encompass every issue that might come up in providers' interactions with criminalized patients. So we really look forward to hearing your thoughts towards the end. And just to sort of ground the content of our presentation and to start with the guide, at the beginning of the guide, we set out just some general principles that we recommend that providers think about when working with criminalized patients. There are some providers like Dr. Puglisi who are very, who work with criminalized patients every day. And there are some people there's other providers who might only encounter criminalized patients that they know of every once in a while. So everybody has a range of experiences that they're coming from, a range of personal experiences with incarceration that they might be coming from. But we just wanted to say some of these things explicitly. The first of which is that the criminal legal system in this country is rooted in white supremacy. So that means that Black people and other people of color have been intentionally targeted by police, by the legal system, including the design of criminal laws themselves. And the result is that Black people and other racial minorities are disproportionately represented in jails, prisons, probation, against and across every component of the carceral state. And this is certainly true in Connecticut. About 12.5% of people in Connecticut are Black, but in January 2020, Black people made up 42.7% of the Connecticut Department of Corrections prison population, which is extremely high. I'm not a STEM person, which is why I went to law school, but I'm sure that all of you doctors out there can recognize exactly how disproportionate that is and how wild those numbers are from a statistical standpoint. And then when we go a little bit more granular, you see that people with serious mental illnesses are disproportionately criminalized instead of being given treatment. And those people are also more likely to be Black and other racial minorities. People who have been criminalized experience poverty at a much higher rate, experience other forms of trauma at a much higher rate. And I think that it's just very important for providers to understand that when you're encountering folks who have been criminalized in the past or are currently in custody, racial trauma is also a part of the trauma-informed care that is important to prioritize with vulnerable populations. It's, as was mentioned before, implicit bias is a huge issue in, I think, every aspect of our culture. That includes the medical profession. I know that our patients and our clients have encountered definitely biased attitudes and very problematic questions and statements coming from medical providers in the past. And as savvy as anybody can be in situations of bias or potential bias, I think that it's just even more important for this particular population to be very intentional, be very aware of whatever bias towards criminalized patients you might be bringing into that situation, what assumptions you might be bringing in, and challenging those. In terms of how to navigate some of those situations, we recommend using person-first language. So for example, incarcerated person or prisoner instead of inmate. Felon is not an appropriate way to describe a patient. Talking about their previous convictions is typically not appropriate at all unless it's related to their medical situation, which is going to be unusual. Somebody on probation instead of probationer, et cetera. And we really suggest that you don't ask someone what they've been arrested for, what they've been charged with or convicted of, unless it's directly relevant to their treatment. So don't be inappropriate is kind of the bottom line there. And you know, a lot of folks who have been incarcerated or have been criminalized in the past often have experienced really poor interactions with healthcare providers, not only in regards to the bias that I was just talking about, but also just bad medical care. People in prison receive very subpar medical care a lot of the time. And that has a lot to do with resources and the ways that prison is set up not to really serve the people that it incarcerates. So folks who are exiting prison often have ridiculous health issues that they would not have had they not been incarcerated. And this is even outside of the COVID context, which I think has some obvious implications. They're more likely to have histories of medical trauma, and it's a more complex population than I think even other vulnerable groups. So just all things to be aware of as we move throughout this presentation. And the bottom line is just to emphasize respect and autonomy and not to make assumptions in any direction about the folks that you're working with. Formerly incarcerated folks, yes, are often traumatized, are often skeptical, are often, you know, there's a lot of very good reasons to kind of be cautious when you're using specific language around incarcerated or formerly incarcerated patients. But these are also patients who deserve your their autonomy and your respect. They are full people with human emotions, and it doesn't matter if there's also a correctional officer in the room. They are your patient. So that's just something to remember as you're working with these folks. And I will pass it along to Ify.
Thank you, Elaine. So the next few slides are areas where we learned that clarity would be helpful, starting with whether or not providers can communicate with the families of folks who are incarcerated. And the top line is that we conducted legal research on this question, and such communications aren't prohibited by state law nor federal law. We looked at HIPAA, including Connecticut state codes, and a few of the legal authorities specifically address the rights of people who are incarcerated, and a few don't. But overall, there were no prohibitions to communicating as medically relevant with patients' families, whether or not they are incarcerated or otherwise involved with the criminal legal system. And one area where a conflict may arise is if corrections staff, law enforcement try to prevent communication. In many prison and jail settings, unsurprisingly, people who are incarcerated have limitations on communications like calls and visits. So there might be an instance where there's a correctional officer in the care setting who says, you can't talk to them. So we included here an example of a way to push back, which both underscores your ethical obligations to your patients and also federal law and patient communications authorizing communications as medically necessary. And so here's an example of a script that you could say that just emphasizes your authority. My ethical obligations are to render appropriate care for each of my patients. This includes communicating with patients' family members as I would do for any of my patients. HIPAA and the American Medical Association's Code of Ethics guide my medical decision-making authority and obligate me to fulfill my duties. I think as a general matter, the emphasis on both your authority and the utmost importance of medical decision-making is probably a helpful thing to rely upon if you find yourself confronting a law enforcement official who is trying to either restrict the ways you're caring for your patients or gain access to some sort of information from your patients, which we'll talk a little bit more in the coming slides. But on this kind of narrow question, there isn't legal authority that says you can't do this if it would be helpful, relevant in the course of providing care for your patients. The next slide, Elaine. Thanks. So this slide and the next slide talk about interactions with law enforcement. Overall, law enforcement officers are not surrogate medical decision makers for any patients, whether or not those patients are currently in custody. And just this relates to some of the themes that my peers were mentioning earlier, but law enforcement presence can be both threatening and very harmful to patients who are criminalized. Many patients have been subject to past police mistreatment. They've been subject to mistreatment in medical care settings as well, and are likely to feel uncomfortable, threatened, intimidated, and unwelcome if they are confronted by law enforcement officers in care settings, which could undermine the patient-provider relationship. Some other harms that are associated with law enforcement presence in care settings are listed on the left-hand side. So police presence can undermine patient privacy. For example, HIPAA prevents unlawful disclosure of protected health information. And if you have, law enforcement officers within earshot, or if you're sharing information, like handing off, a medical record to a patient and law enforcement officers are able to seize it, et cetera, that infringes upon patients' privacy rights, which are obviously maintained whether or not an individual is interacting with the justice system. There's also a risk of undermining patients' constitutional rights and protections against illegal police activity. For example, when police are present, they may be considered lawfully present if their passive interactions or patrols in patient care settings are not challenged. And if that's the case, it's possible that items that are within their plain view can be seized without a warrant. This is one of several examples where there are constitutional rights that can be infringed and police can gain access to information that they otherwise lawfully would not be able to gain access to had they not been permitted to be so close to patients who are receiving care. Police presence can infringe on patient autonomy. As mentioned before, it can cause intimidation, lead to people feeling threatened, and people might not feel free to make autonomous decisions about their care if they observe law enforcement officers present, and undermining the patient-provider relationship, as I mentioned prior. So some effective advocacy can include, back to the prior slide, Elaine. Thanks. On the right-hand side, here are a few bullet points on what effective advocacy can look like. So upholding your right to decline to speak to the police and your patient's right to decline to speak to the police. Speaking to the police is voluntary. Patient does not have to do it. Moreover, if the police are requesting access to protected health information, to your patient's property, do not consent to police requests on behalf of your patients. As I mentioned, patients have legal rights to privacy, and that's unless there are either like a warrant, which we'll talk about in a little bit, or very narrow exceptions, which are largely included in Connecticut state law. So for example, instances of child or elder abuse. Don't consent even if your patient is incapacitated. Another thing that you are able to do is to decline presence. As I mentioned before, there is a risk that passively allowing police to access patients in care areas could be interpreted by courts. Some are great, some courts are bad. I'm a law student, hopefully that's fine to say, as consenting to their activity on behalf of your patients. So even if, with regards to police presence, even if you have a patient who is in custody, so officers are present, officers can maintain a line of sight, but you can request that they stand far away so that they don't overhear protected health information. And another tactic, the last one on this bullet pointed list, is advocate for policies to remove their presence from care settings altogether. Okay, next slide. Okay, so this slide is a continuation on interacting with law enforcement. The left-hand side is kind of a regurgitation of Yale New Haven Health's policies with regards to police interaction. I know we have a few people joining us from the Yale system, so it'd be interesting to learn whether or not how explicit this is made in your training or orientation to the care setting, as well as for people who are familiar with other systems policies, what they say. So without, the first bullet point kind of mirrors or alludes to some of the legal protections that patients have that I already touched upon to some extent, but without patients' consent, patients' affirmative consent, law enforcement cannot interview patients, and that's whether or not they are under arrest. Take evidentiary photos. There's like a narrow exception for where patients are in custody, but even so, if a provider deems that taking photos for evidence would interfere with the patient's health, well-being, care, they can decline. And law enforcement cannot remove physical evidence unless they are acting pursuant to a valid warrant. Also, under Yale New Haven policy, if there's a concern of elopement, if there's a concern about a patient who may flee or something like that, policy does permit law enforcement to stay with the patient until the completion of treatment, and specifically to take instructions from providers on where to wait, which I think links back to the prior slide, mentioning that there are ways, even if your policy permits law enforcement presence, to try to minimize it and protect your patient's rights to privacy, to autonomy, to dignity, to feeling comfortable in the course of receiving their medical care. The right-hand side includes a few suggestions on how to interact with police. And as a small aside, which will come up again later, these are sourced from a really great guide that talks about dealing with police in the ED specifically, which includes additional sample scripts for other types of interactions you may find yourself engaged in with police officers or cops who enter care settings. But starting up top with warrants, at a high level, for folks who may not know, warrants are essentially judicial orders that authorize police searches. Some warrants can authorize arrests. If you're approached by a cop who claims to have a warrant, you should refer them to an appropriate body within your organization who is authorized to review the warrant, which is not the point of care medical provider. So here is an example of what you could say to a cop that says, I am entitled to take, I don't know, X property from your patient. I have a warrant to do so. I can read this out. I understand you have a warrant to, like I said, you can search the patient, access their protected health information, what have you. As a medical provider, I'm not authorized to review your claim, and we don't consent to unreviewed searches or seizures here. You'll need to speak with insert body. I'm not sure how explicit it is within care settings who you would refer a police officer to who tries to access your patient who may have a warrant. I believe, but there are many people on this call who could correct me, it would be the medical records department for Yale New Haven. And if a cop does not have a warrant, you should politely decline the request because they have no legal basis then to be accessing your patient's property, your patient's protected health information. With regards to access, so there's not a legal authority that grants cops, law enforcement officers more broadly, unrestricted access to patient care areas. So if you're in a setting where there is routine and or unrestricted police access beyond, like I mentioned, where a law enforcement officer is executing a valid search warrant, which is legally restricted to a set of actions that they can't do, would not give them free roam of a care setting. It's often a matter of the specific hospital care settings policy or practice. And without a legal basis for the presence of a police officer, if there isn't a warrant, if your patient is not in custody, something like that, here is another example of a way you can politely decline their attempts to gain access to patients. This area is restricted to patients, medical staff, and approved visitors, and we don't consent to law enforcement presence absent a valid warrant that has been reviewed by the appropriate hospital authority, so medical records, legal department, what have you, to protect patient privacy. People who are not patient staff or registered visitors are required to wait outside the emergency department. Follow me and I can escort you there. So obviously there are myriad ways you could think about interacting or how you phrase, how you would push back against law enforcement officers in these settings, but I think we want more doctors, providers, caregivers to feel empowered to push back if law enforcement officers are either not aware of the scope of their legal authority to access people who are incarcerated or are aware and are still trying to gain access, because like we said, patients have a slew of rights that they can, to autonomy, to dignity, that they are able to make choices about for themselves. And also there is a large risk that where a provider is either passively or affirmatively consenting to police officer presence for their patients, the patients could be harmed, both in terms of the care they're receiving, but even more broadly as a general matter, the upside for criminalized patients in interacting with law enforcement isn't really high or there. The downside can be quite detrimental and quite extreme. And we just wanted to underscore that. And next, I will pass it off to Atticus.
Thank you. One quick point I want to add, sort of on top of what Ify was saying, is that all of these concerns apply regardless of whether law enforcement views the patient as a suspect or a perpetrator of a crime or a victim of a crime. The concerns are all the same. I'll just share like a brief anecdote. 2 summers ago, I was working with a civil rights organization, and we were investigating the police department in an East Coast city that had an internal policy of seizing the property of any person who was sent to a hospital for a stab wound or a gunshot wound. So these are people who like traditionally would be viewed as victims of crime, but the police department was essentially sort of taking a blanket sort of surveillance carceral approach to these people who were in critical condition in the hospital. And so we had just numerous accounts of police seizing people's phones, wallets, and backpacks and things like that while they were incapacitated in the hospital. And sometimes the police were able to do that because they just took it and no one stopped them, but sometimes they did it because they were actually guided towards property lockers by hospital staff. And all of that was, of course, like extremely illegal. But it does emphasize the point that that these concerns are valid sort of no matter how the police views the person, whether it's the victim or the perpetrator. And those are, of course, not always the most helpful binaries anyway. Moving on to warrants for arrest. We wanted to clarify for providers that there is a difference between a person who's under arrest and a person who has a warrant for arrest. So a warrant for arrest, which can in the criminal context be called like a warrant for arrest, and in the immigration context is often referred to as a detainer, although sometimes it's referred to as like a Department of Homeland Security warrant. None of those mean that a person is under arrest, and neither under Connecticut law nor under Yale New Haven Hospital policy is a medical provider required to report the patient to police if they find out that the patient has an outstanding warrant for arrest. So just as an example from the Yale New Haven Health policy, quote, law enforcement should not be notified that a patient is being discharged unless the patient is actively under arrest. A pending warrant for arrest is not sufficient to allow notification of discharge to law enforcement. So there the policy is not only that you don't have to report the patient to police, but you actually should not and must not report the patient to police. And then it says the guidance that providers should seek the guidance of the Office of Privacy and Corporate Compliance if law enforcement is making a request related to patient information. And then we'll emphasize that Connecticut law actually prohibits physicians from disclosing a patient's information without the patient's explicit consent. And I believe, as Ify mentioned earlier, there are narrow exceptions when a provider has good cause to believe that there is child abuse, elder abuse, or abuse of an incompetent individual that is occurring. Sorry, Elaine, do you mind going to the next slide? Thank you. When it comes to a patient who has an outstanding warrant for arrest, there is, in addition to not contacting law enforcement, there is a way that medical providers can be helpful to their patient in a way that could, in the long run, be very beneficial to the patient's health. And that is to help your patient get access to a defense attorney if the patient is interested in that and would like your help in doing that. The best way to do that usually is by calling the public defender's office. And there is a sort of like state number that you can call for Connecticut, and then they will refer you to the sort of proper local public defender office. And for immigration problems, that could be contacting an immigration legal services provider. So for example, in New Haven, Connecticut, you could contact Integrated Refugee and Immigrant Services, IRIS. But you can just sort of run a local Google search for local immigrant service providers. You can also, and this is something that's going to come up a lot during our presentation, you can always draft a letter for your patient with their request and their consent. It's a letter that they could give to a law enforcement officer, a parole officer, probation officer, or to the court, explaining the medical troubles, any period of hospitalization or care. In that way, you might actually be able to help the patient, avoid certain charges from escalating or getting out of hand, charges like failure to appear for a court hearing or things like that, those can be excused. And so you as an authority figure and a figure of a lot of legitimacy, you can definitely write a letter for your patient that will help them get around those issues. And then I'll talk briefly about probation and parole. Those are sort of two different terms, but they both describe very intensive supervision of people who are not currently incarcerated. Both involve restrictive conditions on a person, such as their ability to travel, their ability to work, their ability to contact or communicate with people, where they must be at certain times and places and where they cannot be at certain times and places. There are myriad studies from around the nation and going back many years that have shown that it is almost impossible to fully comply with the terms of probation and parole for any person. It is extremely restrictive. It's designed to be difficult. And when you violate probation and parole, it can lead to a warrant for arrest, and or further criminal charges and incarceration. And it's really particularly hard for criminalized people to comply because of struggles with housing, employment, and family issues. Again, if a person is struggling with probation or parole, or you fear that they might struggle with probation and parole, if there is a way in which that struggle is connected to their medical issues, you can again write a letter explaining the medical conditions, the care that this person needs, and the demands that these medical problems have on that person's life, and how it may have contributed to their violation of probation or parole. And that can make an immense difference in a person's outcomes.
Thanks, Atticus. And just echoing what Atticus mentioned about patient privacy and the issues around, taking victims' property or taking, hospitals have been known to give blood samples to law enforcement without a warrant. So these distinctions are actually really important and can make a huge difference in the outcome of your patient's legal case, and also, which is really intimately related to their healthcare, as we've discussed. So I'm going to talk a little bit about shackling policy. I know this is kind of a hot topic. And so I welcome any questions or comments. I'm gonna talk specifically about Yale's shackling policy as an example, but I'll be really interested to hear how other institutions approach this, because I know we have folks from all over the country here. And shackling policies is a really important aspect of effective care for many criminalized patients. And just to begin, I think it's worth emphasizing that there's no law that requires people who are in police or prison custody to be handcuffed or restrained. This is an institutional policy. It's basically a risk management policy. So I'll just read out the current Yale policy, which is that a prisoner or patient under arrest who is under the custody of a law enforcement agency may be restrained for security purposes by the law enforcement agency. Any such restraint imposed by the law enforcement agency requires constant one-to-one observation by the law enforcement agency. So there are a couple potential issues with this. First of all, security purposes isn't defined and could be invoked for any reason. There's really no insight into what providers should do when the restraint might impact the patient's health or their quality of care. There's now a lot of research that indicates that restraints increase the risk of falling and in-hospital death, especially for older folks. And that's particularly relevant given that we have an aging prison population. And there are also accounts of restraints actively hurting patients, including things like handcuff ulcers. It also impacts provider empathy, which goes back to our conversation about bias earlier. And the one-to-one observation requirement for law enforcement implicates the privacy issues that Ify spoke about earlier. None of these are unique to Yale's policy. There isn't, that I know of, any hospital that is doing this perfectly. So even though I'm putting Yale on the spot here, because it's the policy that we work with and the one that I have in front of me, there are policies that really run the gamut around some of these issues. And again, very curious to know how other institutions might approach this. Overall, there's also just a dignity concern. There's a certain indignity in being locked to a hospital bed that I think really does impact health outcomes. So what are some potential solutions? So I'm sure that many of you have had to go through training for restraints in general. For non-incarcerated patients, every hospital is required by CMS to have pretty specific and pretty rigorous guidelines for when it is acceptable to restrain folks in a hospital setting, and the specific form of the doctor's orders that has to take place, the supervision, the reauthorization every so-and-so hours. There's a significant amount of documentation and approval that needs to happen in order to restrain non-incarcerated or non-criminalized folks. And so one potential solution is just to align the policies for prisoner and non-prisoner patients on restraints, and just make the requirements, the safety requirements, the justifications, the health justifications, the same across the board in order to protect patient autonomy, but also protect doctor safety and provider safety in general. I also just wanted to mention the shackling of pregnant patients. I know that's something that has been in the news, I think, probably more than almost any other issue implicating shackling in hospital settings. So this isn't legal anymore under Connecticut law and also federal law. The First Step Act was passed in 2018 and it forbids the shackling of pregnant prisoners. It definitely still happens because there are exceptions for safety concerns that are overly relied upon and exploited. So it does happen, but it is not supposed to. So that's something to be aware of in case your hospital is not up to date on the law. First Step Act of 2018 does forbid the shackling of pregnant prisoners, except for very narrow circumstances. And even though pregnant folks have been protected by these laws, there's no other federal legislation or regulations around the restraint of non-pregnant prisoners. But there have been conversations about protecting other vulnerable groups, such as juveniles or elders or people who are intellectually disabled. So a more incremental approach to moving these policies along could be to expand sort of the protections for pregnant people to these other specific groups, but that does still leave behind a lot of folks. I think that there's also certainly circumstances under which a person who is in custody and is, for example, handcuffed to their hospital bed, is under that one-to-one supervision, but they need an MRI. So those handcuffs do have to come off at some point just because of the nature of their medical care. And that's the provider making those decisions in relation to those person's medical needs. So there is a sort of balance between the provider's recommendations and their power to make decisions about what's going on with their patient, balanced with those like law enforcement decisions and yeah, the balance of power there. So figuring out how to give providers discretion over medical decision-making for their patients and alongside their patients, and formalizing it a little bit more could be one way to push these policies forward. Our hope for this presentation in general, and also on this shackling question, is that this this information, this guide can help empower providers to speak up and advocate for their patients' well-being, because there are infinite circumstances under which the inhumanity of the criminal legal system leaks into the medical system. And we really hope that this will allow providers to help be a part of like really protecting their patients and kind of going above and beyond on their ethical duties to their patients in what can often be a really difficult or a kind of scary scenario. I think for anybody standing up to a correctional officer or a cop can be kind of intimidating. So we hope that this guide can help empower providers to think more critically about the care that their patient is getting, and challenge their institution, challenge the other powers that be that they interact with in advocating for their patients' holistic medical care. And I'm sure that we will talk more about this in our discussion section. I think that this is just a list of additional helpful resources. And I think that the slides and the recording should be available to everybody who registered for the webinar. But there's a series of toolkits and additional like legal information resources that we hope will be helpful. So now we would love your feedback. I think that Ify, you were gonna kind of guide us through this conversation.
Yes, happy to. Yeah, so we're really excited to hear what everyone else has to say. And thank you so much already for your engagement in the chat. It is very interesting, but very hard to multitask because I just want to read what everyone is saying and be up on it. So like Elaine said, we'd love to shift now to kind of the more discussion-based portion of our presentation, and are curious both to get your thoughts and feedback on the guide itself as future generations of students that work with transitions work to revise it, add information to it, just try to make it as useful as possible. And then more broadly, what you've seen in your own work. So perhaps to start, does anyone have questions or feedback on the guide? And related to that, what topics do you feel like are missing and would be really helpful to integrate, or questions that would be helpful to have answered? Or if you have a broader point you want to talk about, open to that, of course, as well. This is to guide conversation, but I think we're really just interested to hear if anyone has, thoughts that are top of mind.
Dr. Sufrin, if you're still on the line, we also welcome your input on the shackling of pregnant women and what you think hospital systems can do more locally. I think I can unmute.
I see we have a question from Natalia. What about providers threatened with obstructing policy / correctional officers in performance of their duties? I can have a quick comment on that, and then if anybody else would like to jump in. My initial impression is, I guess, who's threatening them? I mean, is it the hospital? Is it like hospital supervisors, or are we thinking about like police? Because those I think are two different questions. When it comes to police, it would have to be a pretty extreme situation, I think, for there to be any legitimate ground for obstruction of justice or an obstruction of arrest. So I would guess that unless it's a pretty extreme situation, those threats would be empty. When it comes to violating hospital policy, that would really depend on the hospital's own policies and how they conflict with a provider's need to fulfill their duties to their patient. So it's kind of situation specific and hospital specific. But I think I guess my question would be, who are we talking about and what are the consequences? Because it might sound scarier than it actually is. That's my first impression. If anybody has other thoughts.
Elain, I would add to that I think what you showed in the very beginning, to kind of really center ourselves on what our actual legal obligations, our ethical obligations are that your license depends on. You have to click off ethical, standards that you're going to follow when you renew your license every year. That is a grounding spot, right? Like if you are acting in good faith of your license and ethical obligations, that is to me, a really kind of safe-ish spot to be in. If your acts are within that sort of context. And so I think there actually is a lot that can guide you and protect you, which is that you're trying to follow the rules that you said what you were going to do and promised and swore and, and are licensed to do. The other part I'll add is that as I, supervise resident teams on the floors and we think about what patient care is, like it's everything. When you're the provider in the hospital, everything's under your control. You have to rein in consultants. You have to rein in the discharge plan. You have to control it and monitor it and make sure it's right and make sure everything's just so, and make sure that communication is just so that people understand and there are not miscommunications that lead to medical errors. Think of all the training you've got on that and how little you've gotten this. And it's 100% a critical part of a hospital experience, right? So for those on the line, I think mostly we're thinking that this isn't our alley, but who question it, which I am really sensitive to. It's something I continue to learn about more every day. I think it couldn't be more in your alley, right? As the primary provider, this is all in your alley, under your obligation really to the patient. So I just want to throw that out there as well. I think we have some other great questions here too. There was a good question about medical decision makers. So I wonder what our legal team has to say to, in the state, I think it's Louisiana, it follows the same as for non-detained individuals. Is this state-based or are there any national guidelines of medical decision makers for detained individuals without decision-making capacity? It's a fantastic question. What do y'all think?
I'm happy to start. Yeah, that's a really interesting question. And I haven't done research on like that very like specific legal question, but more broadly was researching where there are differences or carve outs for patients who are criminalized versus those who are not. And I haven't come across any national guidelines or regulations that change who the medical decision maker is based on incarceration status. And I haven't seen anything that would imply that anyone within law enforcement would be the medical decision maker for a criminalized patient. And obviously there's a lot of harm with that. That's what I've seen from my research. I don't know if any of my peers have looked into this question or have anything to add, but from what I have seen, I haven't come across legal authority that suggests that incarceration status is the basis to change who would be authorized to make decisions for patients who are incapacitated in some way.
I have gotten the similar sense from what I've read, Ify. I'd also add that although I don't think that there's any legal basis that, automatically gives legal decision-making to the prison system, or takes that decision-making away from someone who would otherwise have medical decision-making power, would have that assigned to a family member. We know from practice that this happens all the time, where a family member isn't allowed access to the hospital, or a patient is unconscious and the CO makes the call, which should not be happening. So as providers, just be aware that this is a type of rule that is broken all the time, and you may be in a position of being able to protect your patient's rights in this scenario by pushing back a little bit.
Great. Also open to people raising their hand if they want to speak out loud, or I wonder if there's other questions, MLP team, that you see on here that we ought to be addressing. There's so many great comments.
One comment I saw was people going back and forth about how to integrate into training of new physicians and providers this information. So another question you'll see on the guide is how would be like the best way to disseminate this so it's accessible to providers for caring for criminalized patients. So we invite thoughts on anything related to the guide or your personal advocacy and what you've seen, but also curious if people have additional reflections on how to make sure this reaches as many people as would be helpful.
I gave it the good 2 minutes. Oh, good, we're hearing from somebody regarding starting to do some training for residents at BU Medical School on carceral health. It's been really well received. Fantastic. And at Tulane, they're doing it for training for residents as they enter residency. Well, that's where we're hoping to move at Yale too. We're also on our SEICHE Center website within the next 2 months or so should have some form letters up that people can use so that you don't always have to go back to the drawing board, and you can build upon some advocacy letters that we're going to be sharing as examples to make your advocacy easier for you. It's actually usually pretty fast once you have something to work off of and do some edits. Now we have some more stuff coming in. Let's see. Medical and residents are key in Dr. Khatri's opinion. I think that I totally agree. I think we have to go up and down the whole line and the whole system though, in my opinion. Great. Well, I think that if there's not other comments and if nobody has their hand up, we'll wrap up a little bit early, but I wanna thank everybody who joined us because there's been great energy on this call, and that's what we were really hoping for. We imagined it to be rich with chat, and it really was. We also recognize this is a limited audience, and so our work next is to kind of disseminate more broadly in all of our different institutions. Hopefully this is a start point for some of us. And we appreciate your feedback. We're going to be kind of going through all of the chat and thinking it through, and we appreciate you. We're grateful. We're happy to continue to connect. Please reach out to us. We have a SEICHE Center website at Yale. That's SEICHE that I'll put in the chat. And I'll put our emails, mine and James' emails as well, as we'll be here till kingdom come. So thank you. The people I'm most grateful to are Elain, Atticus, and Ify, who I have learned a tremendous amount from this past year, and who are incredibly tolerant of my crazy directions and in my questions that go in a million directions every time I see them. But there's a real feel of desperation sometimes, like there's so much we have to do. So thank you for walking on this path with us. And we're so excited to see the paths that you continue to walk down yourselves as you develop your own careers. And I just see like beautiful stuff to come. So thank you. We're grateful for you. And thank you to all the people on who made time to join us today. Have a beautiful day.